This round of turnover now,
Thank you, Chairman. My sister Amagoba. Well done, you've done well.
Thank you very much, Honorable.
There is the issue of whether or not to cap the number of Supreme Court judges. Currently, according to information, we have 13. If 7 of you go in, and inshallah you will be 20. What is your suggestion about the numbers? Should we add up, just leave the law like that, continue to add up, or we should cap it?
Thank you, Honorable Chair. I believe in capping the number of Supreme Court judges, but I believe that we should not hasten to do so until we have resolved the issues that confront the Supreme Court, which require that the numbers be increased. Because if we cap it and there's a justification for an increase, it would mean that we would subject our Constitution to constant amendments, and that will not be desirable. But if we are able to solve the problems at the Supreme Court, the backlogs, the various jurisdictions that it has, then we would have a fair idea of how many cases on a year-by-year basis would go to the Supreme Court. And then we can have enough reason or basis to cap the numbers. Thank you, Honorable Chair.
Chairman, my second question. My second question has to do with the establishment of regional tribunals, and that is Article 142 of our Constitution. And when you look at it, the membership shall consist of the Chief Justice, one chairman, and 6 members who may or may not be lawyers. Do you subscribe to our having regional tribunals? And if the Chief Justice is supposed to be part of the panel there or the team there that is going to work, how do we get enough of such people at any given time so that it shouldn't be like, oh, the Chief Justice hasn't come, so we do not know what to do. Let us postpone the case, let us hold on, and maybe when she's ready or when he's ready, then the case will be heard, where our cases will be prolonged.
Thank you very much, Honorable Chair. I do not know the policy rationale for why the tribunals, the regional tribunals, were abolished, so to speak, or were subsumed into the regular court system. But it still remains part of our law. And the law says that it is the duty of the Chief Justice to establish regional tribunals, and the duty of Parliament to prescribe exactly what their jurisdiction should be in respect of state matters and public interest matters. And so, insofar as the regional tribunals still remain part of our laws, I do not have any aversion to regional tribunals. I would also like to say that the Chief Justice is a judge of every court in Ghana. The Chief Justice is the first judge of every court in Ghana, but she does not sit when it's in Parliament, even though she can decide to sit. So ordinarily, a 3-member tribunal doing its work would not require the presence of the Chief Justice to sit. Thank you, Honorable Chair.
Thank you, Chairman. I'm most grateful. I wish you all the best.
Thank you very much.
Thank you. I'll give the floor to Honorable Bid Sidin Awandazuma.
Thank you very much, Honorable Chairman. Your leadership, congratulations for the nomination.
Thank you very much, Honorable Chairman.
And let me tell you that we, the Upper Westerners, we are very proud of you.
Thank you.
I made this statement when His Lordship Sulbare appeared before us, and I indicated that we are happy to have 2 Supreme Court judges coming from the Upper West region because you will be approved. And we are further proud of you because we have the first lady Chief Justice also coming from Upper West. We hope that in course of time, our colleagues in the other northern regions will also benefit from this exercise. Anyway, ordinarily, I should not be asking you any questions, but I'll just ask you one question. But even before the question, some small comment. You are a Christian, but it's surprising that your first name appears to be a Muslim name. I'm curious about that. I will not expect any response from you, but it is interesting that you are a Christian and yet you have a Muslim name. I believe that the second name is your husband's name, and your husband must be one of our playmates. So it is all good. The Chairman, you are not happy. Where you are looking at me.
Yes, because you have to ask questions.
Yes. I'm coming.
You are not to run a commentary. And you know you are violating the rules of the House.
Sometimes.
So you don't expect me to be happy when you are violating the rules.
Thank you very much, Mr. Chairman. The question is, the retiring age of public servants in this country is 60. Sometimes it is extended to 60, a maximum of 65, 61, 62, 63, but maximum of 65. But justices of the Supreme Court, they retire at 70. So it appears there is some discrimination because these categories of people are all serving the Republic. Your leadership, in your view, is there justification for the difference? Other public servants retire at 65 maximum. Judges retire at 70. Is there any justification for this difference? Thank you.
Thank you, Honorable Chair. The justification that I see is that in the administration of justice, we need qualified, experienced jurists to be able to adjudicate matters that will stand the test of time and to be able to also guide relatively younger judges on how to proceed. So we need experienced jurists in the Supreme Court because that is our final appellate court. It is also our constitutional court and it has various other jurisdictions. So I believe that the age is important because of the experience and qualifications that the jurists would have gathered over the years. Thank you very much, Honorable Chair.
Mr. Chairman, that will be all for now. Thank you. And I wish you very well.
Thank you very much, Honorable Pete. Yes, Patrick Yawoma.
Thank you, Chairman. Congratulations, my lady. Thank you. My lady, I've gone to your CV and I've realized that you've chaired quite a number of committees aimed at reforming the judiciary or the judicial service. Committee to investigate allegations of procurement of fraudulent divorce certificates other court documents, 2023. Committee for setting up attestation units in other regions and for digitalization of the said units, 2023. Committee for implementation of recommendations made by the committee to investigate allegations of procurement of fraudulent divorce certificates and other documents, 2024 to date, and a host of other committees. I would want to know from you how the implementation process has gone on with regards to some of these committees that you've chaired, and remedies they seek to achieve in advancing our judicial process and also promoting the integrity of the courts.
Fraudulent documents and the attestation units. These two are linked. So it is the aim of the Judicial Service to ensure that people do not procure fraudulent divorce certificates and documents and parade them as coming from within the Judicial Service. So what has happened so far is that we intend to start a process the stations which can be forged by people outside of the service. But if we have all of them passing through the system, then it's easy to track and ensure that we don't have forged documents out there. But with the attestation unit, what has started happening is that if you take a document to the attestation unit for attestation, your ID card would be taken and a photocopy would be made of it. Now, and documented, if it is realized that the document is a forged document, you will be reported to the police and you will be arrested. So that is how we have started working in respect of these committees. Thank you very much.
Chair and Supreme Court, some became Chief Justice and what have you. I believe when you go to the Court of Appeal, you met some senior members too there, and by God's grace, gotten the opportunity to be nominated. What would be your advice to those of us around the table that nominations are not political, are based on certain steps or considerations? And that's one of the reasons why you are before us. So what do you have to say to some of this? You see, you politicians.
Honorable Chair, I would...
And what an accused person ought to be, the opportunities that accused person ought to be given, right to counsel, facilities, what have you. And reading that in conjunction with I think Section 967 of Act 30 on bail. Sometimes bail conditions are a bit too onerous that a lay person can easily say that this will amount to being denying the person bail or amounting to punishing the accused
for trial, and that at the end of the day, if you should abscond, the sureties who have signed your bond would be able to meet whatever conditions are required of them. And so it is not supposed to be a punishment. So if you are unable to secure bail or the conditions are onerous, you either apply for a variation or you appeal, so that the appellate court can take another look at it. Thank you very much, Honorable Chair.
Thank you, my lady. It will surprise you that you appear before a judge, and the mood of the judge will be that, oh, yes, I've refused your application, you can go up. Straight away. And without considering the merits of the application, so okay, I've read and I'm refusing, you can go out.
And ensure that the appropriate training is done. Thank you.
My lady, on that note, I wish you the very best. God bless you.
Thank you very much. Honorable Jerry, you have the floor.
Thank you very much, Honorable Chair. Honorable nominee, congratulations on your welcome. Lady, you've been in this practice for 26 years, and you've dealt largely with the issues of dissolution of marriages. Lady, family law cases increasingly involve complex constitutional questions regarding gender equality, children's rights, and traditional versus modern family structures. Given your very extensive experience in family law, how do you view the Supreme Court's role in balancing traditional family structures with evolving constitutional principles of gender equality?
Honorable Chair, can the question be clarified?
The question is seeking to know how you intend to use your background as an expert in family law to deal with issues of constitutional matters, especially people are now making more or concentrating their attention on gender equality. How do you marry the two? How are you bringing your rich experience on family law to deal with issues of gender equality?
Thank you, Honorable Chair. And when it comes to family law, the principles are applicable equally to men as it does to women. Because when it comes to distribution of marital property, it is not based on gender, even though it may seem so. It may seem so, but the law is not based on gender. Because it says, Article 22 says that assets acquired jointly during marriage are to be distributed equitably. And whether, irrespective of their gender, that is what the provision is. So it is not in any way discriminatory of any gender. That is my answer to the question.
Well, just a follow-up. Have you handled cases where the man seemed not to have properties, but the woman seemed to have properties, but they had these properties during the currency of the marriage, and then when it came to distribution, there were issues because the man was now requesting that the properties be shared equally?
I do recall that there was a case before me where the man did not have properties, but the woman did. And I gave the man part of the woman's properties. The man did not have properties, but the woman had properties. And the man was entitled to a share in the woman's properties. And that is exactly what I did. Thank you very much.
Thank you very much, lady. The Supreme Court frequently addresses cases involving children's welfare that require balancing parental rights, state intervention, and the best interest of the child. Lady, how can the Supreme Court interpret constitutional provisions regarding children's rights when they conflict with this parental authority or cultural practices?
Thank you, Honorable Chair. The law is clear that in every matter affecting children, the welfare of the child is the court's primary consideration. So in all matters affecting children, it is the welfare of the child that is the primary consideration. So that is what the law says, and that is what is applied in the courts. Thank you, Honorable Chair.
Lady, have you had the occasion of dealing with a matter that the welfare of the child, although very key, the Constitution perhaps also had a position, and therefore you felt a bit conflicted, especially as a mother?
Can I have a clarification of the constitutional conflict? I'm not too clear on the conflicts. Thank you.
Well, maybe there was a set like there, you just give a response, and then there was the basis for you to proceed to say that, well, the law is the law, and so I need to proceed to give a judgment or make a decision or a determination based on the law. But you also felt that at this point in time, maybe you could have considered the child's welfare more, but it's still conflicted with the law, and therefore you proceeded to deal with the matter the way you had to deal with based on the law.
What I said was this, that where a child's welfare is in conflict with a parental authority, you said, then in that case, the child's welfare will be considered. Because in considering the child's welfare, you must find out whether or not what the parent seeks to, the authority the parent seeks to exercise is in conflict with the rights of the child. And if it is in conflict with the rights of the child, then you need to prioritize the welfare of the child. That was what my explanation was.
Well, I think it's well understood. Lady, this will be my last question. Is how do you envision the Supreme Court's role in developing constitutional standards for ADR, alternative dispute resolution mechanism?
Thank you very much, Honorable Chair. The ADR Act is the standard for resolution of disputes by either mediation or arbitration. And I believe that this is what is enforceable, even in the Supreme Court. If the matter should probably go to the Supreme Court, but not on the merits, because you cannot appeal against an arbitral award, for instance. You can only seek to set it aside on procedural or other grounds, but not on its merits. There is no appeal in respect of that.
Are there any recommendations you would want to make in reference to ADR, the ADR mechanism?
Not immediately. I can't think of any immediately.
Very well, my lady. I wish you all the best, and congratulations once again.
You're done, Honorable Chair. All right, I will now call on Honorable Lefiamapo. You have the floor, Chief Whip.
Mr. Chairman, thank you very much. My lady JS is soon to be. You're welcome and congratulations. During our formative years at the bar, you were one of the few lawyers that anytime you step into court, we had to wait to listen to you. And then when you got elevated onto the bench, we had a tough time before you. So you didn't get here by accident. You merited it. And I'm very proud of what you have achieved so far.
Thank you, Honorable Chair.
I have two questions by way of policy. And so I'll zoom straight into the first one. One of the jurisdictions of the Supreme Court, by way of appellate jurisdiction, is to hear matters emanating from the National House of Chiefs when an aggrieved party, after exhausting the procedure, then proceeds to the Supreme Court. Now, in Articles 271 and 273 speaks of the chieftaincy institution and the National House of Chiefs and the Regional House of Chiefs. Now, in the Constitution, there is a provision for lawyers to assist the judicial committees when they are determining chieftaincy issues. The National House is to be assisted by a lawyer of not less than 10 years. The regional ones, a lawyer of not less than 5 years. We didn't make any such provision for the traditional councils, the judicial committee of the traditional councils. But we borrowed the spirit and letter of the Constitution, inserted it in the Chieftaincy Act. But the arrangement creates a problem because, I'll set the question, it's a background. The matters that eventually will come before you at the Supreme Court emanates from the judicial committees of the traditional councils. And then we ask lawyers of less than a year or not at least 1 year to assist them. So where error occurs, it then travels all the way to you up there. I know it's this house that must make amends. So will you support a proposal that instead of the lawyers assisting, they are made to participate in the proceedings by being part of the panel instead of being made to assist? And because in most cases, I've done by way of work, we've done some chieftaincy cases, and the traditional councils don't have money to hire lawyers. So it's the chiefs who go on and handle the matters, riddle with errors. It gets to the region. Some too don't have resources to engage lawyers. So it's the national that really have some lawyers assisting, by which time the damage would have been done.
Thank you, Honorable Chair. I believe it's a laudable suggestion and one that I would support. And invariably, it would also reduce the workload at the Supreme Court. Thank you very much.
Great. My other concern is in respect of the matters containing Article 153 and 154, the Judicial Council.
Sorry, Leader. Is this a follow-up or is it a new question?
Chair, I was very clear that I have two questions. Yeah. The first one is done. Okay. So the second one is in respect of the Judicial Council, creature of the Constitution.
Go ahead.
If you look at the composition presently, a very key stakeholder in the justice administration and delivery channel is not included, which is the Ghana Prison Service. Again, would you support the proposition that we should have a representation of the Ghana Prison Service as part of the constitutional amendments represented on the Judicial Council?
Thank you very much, Honorable Chair.
Especially in view of your functions, in view of the functions that the Judicial Council performs.
Thank you very much, Honorable Chair. I believe it's a good proposal because it would seem to me that the prison service is an important stakeholder in the administration of justice. Thank you.
Chairman, thank you. Let me once more congratulate you, and we wish you all the best. And we'll look forward to appearing before you in the future.
Thank you very much.
Congratulations.
Thank you.
Thank you very much. It's the turn of Honorable Patricia PJ. You are Deputy Ranking. You are on the floor.
Thank you very much, Mr. Chair. Mr. Chair, I'd like to take this opportunity to congratulate our lady. And I'm actually ceding my time in order for you to live here. I'm ceding my time to the minority leader to go through. Thank you very much.
Thank you, Honorable Chair.
Thank you very much. I will now cede the floor to Osahini, the ranking member. Thank you.
Thank you, Chairman.
Please go ahead. Please go ahead.
I just heard that you are going to call the majority leader after I'm done for re-examination. Then you call him. He as a leader is entitled to be here. Call him. The practice and the protocols which he knows is that I'm the last. I'm your ranking. I'm the last to ask. So if he wants to ask, let's allow him to ask his questions.
Honorable ranking member, at the moment, I am the chairman of this committee, and I'm the last person to speak. So I indicate who speaks next. You are on the floor. Thank you.
All right. At least what you just said has become part of our records. A good precedent, no problem. When I'm done, just call the majority leader to do his re-examination, no problem. Honorable nominee, we did some checks based on your own CV you brought to us. I want you to clarify for the record. Where did you do your national service?
I did my national service after A-level at Kangbli JSS, Kangbli Junior Secondary School, in the Western region.
Very well. My lady, please, in your time after doing your national service, are you issued a certificate during those periods? Were you being issued with certificates?
I did not get a certificate. I did not get a certificate when I finished. I am sure I could have applied for a certificate, but I did not get a certificate. Yes.
The reason I asked you, in all fairness, is because National Security got back to us that they have no such records of you having done your national service at Kangbunli JHS in Western Region. That's why I wanted you to clarify. Because
I did.
Very well. So you may have to furnish us with some other details you have later, not now, just to confirm. All right. Now, what is your age now, please?
I'm 52 years old. 52 years old.
Very well. So what it means is that if the opportunity avails itself, you would have some 18 years to serve on the bench.
That's it.
My lady, I intend to take your thoughts on Articles 286 and 287 of the Constitution. I would preamble what I'm going to say. With recent decisions of His Excellency the President regarding imposition of salary fines on ministers and appointees who fail to declare their assets.
Are you feeling irate? All right, make we answer them now.